ground rules also known as idiosyncrasies. Because I'm scoring, and you're going to have to be addressing the jury, I don't care if you don't need to look at me as if I were a juror. However, I need to be able to hear you. So you need to keep your voices up even though you're addressing the jury, and please don't speak when your back is to me, not because I'm offended by that, but because I won't be able to hear you. Also, if you have an objection to make, just get up and make the objection. I'm just going to look at the other side, and that would be your sign to say whatever it is you want to say in response to that. With that, can the prosecution please introduce themselves to the court?
Yes, of course, Your Honor. My name is Lauren Gerber. My co-counsel are Rahul Srinivas
Good morning, Your Honor.
Good morning.
and Amani Walks.
Good morning, Your Honor.
Good morning. And the defense?
Yes, Your Honor. My name is Jaleesa Harris, and my co-counsel Will Rogers,
Good morning, Your Honor.
Good morning.
and Dale Ballback.
Good morning, Your Honor.
Good morning. Are there any preliminary matters from the prosecution?
Yes, Your Honor. Before we begin, we have several documents we'd like to tender to the bench for Your Honor's reference. They include the indictment, stipulations, penal code, case law that's been deemed relevant by both parties, and the Midlands Rules of Evidence. Do I have permission to approach the opposing counsel and the bench with these documents?
Yes.
Next, Your Honor, the state would like to invoke Rule 615, which calls for the constructive sequestration of all witnesses, barring party representatives.
Any objection?
No objection, Your Honor.
So granted without objection.
And lastly, Your Honor, we'd just like to know your preferences regarding moving about the well of the courtroom, and specifically if you'd like us to ask permission to approach the bench, opposing counsel, the witness, and the jury.
You don't need to ask permission. However, if you're going to tender something to the jury or to me, you need to clear it with opposing counsel first. Also, I don't care where you stand. However, I want you to be cognizant of the fact that I don't want you to be blocking the view of the witness of opposing counsel. Now, if that happens, I don't want opposing counsel to object and say he or she can't see. Just whoever is blocked should move, physically move wherever it is so they can see, because I don't want to break up either the direct or the cross for that. Is there anything further?
No, Your Honor, the state is ready to proceed with openings.
Is there anything from the defense?
Yes, Your Honor. According to Rule 615, our party representative for today's case will be Mr. Chase Covington.
Good morning, Your Honor.
Good morning.
And with that, the defense is ready to proceed.
Okay. So we can go right to opening statements.
Opening to the state, Your Honor.
Yes, sir.
Your Honor, opposing counsel, members of the jury may it please the court. A bid, briefcase, a bribe. It's April 17th, 2015. The defendant, a public official, is entrusted to make the right decision. He's entrusted to make the right decision for Midlands. He's entrusted to make the right decision for his community. But instead, the defendant makes the right decision for his bank account. In October of 2014, the Midlands State Gambling Commission announced that it would be accepting proposals for someone to open a new casino in Midlands. They received two such proposals. One from Shannon Stark, a poker player, and the other from Avery Bancroft, the owner of the Black Bear Casino. And on April 17th, 2015, they were set to vote on which casino they thought was better. Now, members of the jury, you'll hear that the Midlands State Gambling Commission was made up of 3 members, but that 2 of these members, Harper Walton and Riley Geist, always voted against each other, meaning that it was up to the defendant, Chase Covington, to decide who ultimately got the new casino. Members of the jury, today you'll hear from Officer Mickey Keenan, a police officer who worked undercover at the Midland State Gambling Association. Officer Keenan will tell you that just 4 days before the vote, Chase Covington said that he probably wasn't going to vote for Avery Bancroft's proposal, but that he could be persuaded. Then you'll hear that on that very same day, Avery Bancroft and the defendant had a meeting in which Avery Bancroft offered the defendant a note that said yes equals $150,000. But it was only after Ms. Bancroft raised her offer to $250,000 did the defendant accept that note. Then you'll hear on April 17th, 2015, Chase Covington voted to give Avery Bancroft a new casino. And on that very same day, Chase Covington deposited $200,000 in cash into his bank account. Now, members of the jury, Officer Mickey Keenan wasn't the only person who sat in on that April 13th meeting. You'll also hear from a bellhop at the Black Bear who delivered room service to that meeting, Mr. Devin Del Sesto. Mr. Del Sesto will take the stand and he'll tell you that when he went into that meeting, Chase Covington had a black briefcase with him. And then 2 days later, Mr. Del Sesto will tell you that he saw that same black briefcase. But this time, Avery Bancroft had a briefcase of her own. And Mr. Del Sesto will tell you that when Chase Covington walked out of the Black Bear Casino that day, it didn't look like he was carrying the same briefcase he came in with. Now, members of the jury, how do we know that the briefcase was the vessel for the bribe? Well, we'll hear from Dr. Pat Sikorsky, a forensic expert who analyzed the briefcase that was confiscated from Chase Covington. Dr. Sikorsky will tell you that Avery Bancroft's fingerprints were on the briefcase and Avery Bancroft's hair was inside the briefcase. Dr. Sikorsky will tell you that he concluded that Avery Bancroft handled the briefcase before it was confiscated from Chase Covington. Now, members of the jury, in bringing this case before you today, the state has taken on the burden of proof. And what that means is we have to prove to you that Chase Covington accepted a bribe. We have to prove to you that Chase Covington accepted money, and this money influenced his decision to vote for Avery Bancroft's casino. And we'll meet our burden today. We'll meet it because of 3 things: the bid, the briefcase, and the bribe. And that's why at the end of today's trial, my co-counsel, Miss Amani Walks, will come before you and she'll ask you to find Chase Covington guilty. Thank you.
Ms. Harris, when you're ready. Oh, I'm sorry.
Your Honor, opposing counsel, members of the jury, it simply came down to experience. You see, in October of 2014, the Midlands Gambling Commission announced that they will be accepting and voting on proposals for a new casino to go up right here in the state of Midlands. After about a year of review, it came down to 2 candidates, but only one has significant and relevant business experience. The defendant, Mr. Chase Covington, is the chair of the Gambling Commission, and ultimately he had the swing vote to decide who would get that casino. Members of the jury, he voted for the person who had the most experience. It's that simple. But yet the state, if they just came before you and they told you about a conspiracy of a bribe, and they want you to believe that on April 16th, 2015, the defendant, Mr. Chase Covington, met with one of the candidates, Ms. Avery Bancroft, and accepted a bribe. They want you to believe that in this bribe, Ms. Avery Bancroft filled a briefcase filled with $200,000, then handed it off to the defendant. But members of the jury, I want you to pay special attention in today's trial. Because out of every single witness that takes that stand today, not one single witness will be able to tell you that they saw Mr. Chase Covington accept money from Ms. Bancroft. And members of the jury, that is exactly why we are here today. Because the state, they have the burden of proof in today's case. And they have to prove to you 3 elements beyond a reasonable doubt. Now, when I say beyond a reasonable doubt, that means after hearing all the facts and all the evidence that comes out in trial today, you cannot have any doubts based upon your own common sense or reason. Now, this is the highest burden in our justice system today. This is the highest burden to prove, the most challenging burden to reach, and they have to prove to you each and every element beyond a reasonable doubt. The 3 elements that they have to prove to you today are 1, Mr. Chase Covington is a public official. 2, Mr. Chase Covington accepted money. And 3, and Mr. Chase Covington, when he accepted this money, had the intent to be influenced by this money to vote for Ms. Bancroft. Members of the jury, they will not be able to prove that to you today. To show you that an exchange did not happen, we will be calling 3 witnesses before you. First, we will call Avery Bancroft's executive assistant, Corey Hyde. Ms. Hyde will tell you about the events leading up to the vote. How they set up meetings between the chair of the commission and Ms. Avery Bancroft, and they went over her proposal. And how in the end, Ms. Bancroft, she simply had more experience than the other candidate. And that's why Mr. Chase Covington cast his vote for Ms. Bancroft. Secondly, we will call Ollie Thomas. Ollie Thomas is a blackjack dealer at the casino. Now, Ollie Thomas was there on the day in question, April 16, 2015. And both Avery Bancroft and Chase Covington entered into the VIP room, and they did have those briefcases. But members of the jury, I want you to listen carefully, because she will tell you that they never switched briefcases, they never exchanged money, there was never a bribe that took place on that day in question. Lastly, we will call Mr. Chase Covington himself. Mr. Covington, he will tell you about the day, April 17th, the day of the vote, and why he voted for Ms. Bancroft. He will tell you that it simply came down to experience and how he got arrested, and how on that day there was no money in that briefcase. He never accepted a bribe. It was all a misunderstanding. Members of the jury, throughout today's case, not one single person will be able to tell you that Mr. Chase Covington accepted money. As members of the jury, it simply came down to experience. That is why at the end of today's trial, my co-counsel, Mr. Will Rogers, will come before you and ask that you find the defendant not guilty. Thank you.